back on the air. This is Jeffrey Davis, and this is Radio Entrepreneurs, always featuring stories about entrepreneurs and people who work with entrepreneurs. Our next guest, we met a few years ago in another forum, David Rouille, I hope I pronounced it right, of Anderson, Gorecki, and Rouille, patent attorneys, correct?
That's correct.
Now, I used to think when I was younger, earlier in my business career, that patent attorneys, that's kind of a boring kind of field. It's sort of like your grandfather's profession, but it's turned into it's the wild, wild west of patent attorneys, isn't it?
Yeah, it's funny. Like I do patent prosecution, so I prepare and argue before the patent office to get the patents allowed. And my son, who's not into technology as far as patents at all, he says, "Dad, all you do is write book reports all day." That's a little oversimplification, but.
But Boston alone is a hub.
Oh, there's all kinds of high-tech stuff going on.
High-tech, startups, ideas.
Startups, ventures, and you also have all the schools. MIT, I do work for MIT, and they come up with some unbelievable technology.
Wow.
Good stuff.
So tell us about the current world, what's going on, the trends.
Yeah, so.
You're first to file, right?
That's it. That was the biggest change. A couple of years ago, President Obama signed in the America Invents Act, and that changed a lot of things. The biggest thing, in my opinion, that changed was, like you said, the first to file. Before he signed that bill, the U.S. was the only country that was first to invent as opposed to first to file. So if you filed for a patent and I filed for the same idea a month later, if I could prove that I invented it before you, even though you filed before me, I would be awarded the patent.
Right.
And that was different than the whole rest of the world. And in order to, everybody plays by the same rules because it's really more of a world economy now. They passed the American Invents Act, where now the U.S. is also first to file. So it's basically a race to the patent office. And if you file first, and you get the patent.
But getting the patent doesn't mean you can protect the product.
Well, a patent doesn't give you...
filing a patent isn't easy, is it?
It is when you hire my firm.
Well,
okay, usually what will happen, let's say, if you have an idea, you would approach me and say, "Hey Dave, I've got an idea, I might want a patent." And I would interview you. I'd say, "What problem does your invention solve?" And once you've defined the problem, then tell me how your invention solves the problem. And that way I get a good understanding of exactly what you're doing and where you're coming from with the idea. And then prepare a draft, send it to you for review. You look it over, any changes you want to make, we talk about it, get it in the final form, and then we file it. And once it's filed, you can start using the words patent pending on your products and any white papers, presentations, web pages.
And a legitimate firm like yours, you're not going to file unless you're pretty convinced that you're going to get the patent, correct?
Yeah, we're pretty sure.
So in today's world, with the right patent attorney like yourself, if I see patent pending, I should assume patent going to be received.
Potentially, yeah. I mean, it depends. People.
Is there a batting average?
I want to say it's about 80%.
Okay,
For my firm, it's about 98%.
Right.
But there's different things you can do. We have a process where we'll talk to the examiner, because the examiners are looking at this. They've never seen it before. They look at it, they do a search, they reject it on what they've come up with on their search. And a lot of times, just from reading it, it's tough to really get a feel for it. I mean, you should be able to, but you call up the guy and you say, I don't understand why this rejection exists. I'm doing this with an access point, talking to a wireless router. This guy's using hardwired networks. This is different because I'm going to roam and I might go to a different access point. And he'll say, oh well, if you define in the claim what the access point is, then I'll reconsider it. We have a website. It's S as in Sam, M as in Mary, M as in Mary, A as in Andrew, law.com, smma.law.com. If you want to email me, it's my first initial last name at smmalaw.com, so it's DROUILLE. And you can always call us at 978-264-4001.